Ready?
Please.
Yes, I'm here today because I was issued a ticket for traffic for not having a sticker. I believe it was tags, and I challenged the ticket for jurisdictional, lack of subject matter jurisdiction and personal. And I presented the issue to the judge in the lower court, and I put it on in motion. And then when I went before the court, I had spoke out. In the process, in my earlier stages, I had used, it was a remedy, which was under the UCC. And the remedy was without prejudice. I had put the without prejudice on my stick, on my driver's license, for what the remedy said it was the use for. So when I had put the without prejudice on my driver's license, or whatnot, I had a previous case before another judge in the lower court. The lower court, he basically said that the without prejudice, it didn't apply to me or whatnot because I presented it to him or whatnot, and I had my case. So the case was rendered against me, and I had I pay a fine. So in the process, I had went through the process of becoming a secure party creditor. And basically, my whole thing of becoming a secure party creditor is because I wanted to travel and have my rights under the Privilege and Immunity Clause to be able to travel. And under Packard v. Gunnell, the United States Supreme Court had ruled, said that we had a right to travel.
Orly Ahroni on behalf of Appellee. Good morning. Ohio's motor vehicle registration laws requires that the owner of a motor vehicle who drives his car on public roads to register his car annually and to pay the tax for it. And the purpose of registering a car is to establish ownership. In case of car theft, for example, or violating a traffic law, or becoming involved in a car accident. Furthermore, requiring a tax to be paid assists the state with the cost of keeping the roads in proper condition. Now, the defendant argues that Ohio's...
The Ohio Constitution...
I'm sorry?
Doesn't the Ohio Constitution say that money has to be spent for improvement of roads when it deals with the motor vehicle?
Yeah, and the case law also. I mean, it talks about that. It's for the improvement of roads, for the upkeep of the roads.
It's a constitutional provision too, I think.
Okay. I'm not sure about that. It could be, yes. But I know the case law that I found actually supports that argument also. And now, the defendant argues that Ohio's motor vehicle registration law violates his constitutional right to travel. First of all, the standard is an enactment of the General Assembly is presumed to be constitutional. And before a court may declare a law unconstitutional, it must appear beyond a reasonable doubt that the legislation and the constitutional provisions are clearly incompatible. And the defendant in this case has simply not made that showing. There is a constitutional right to interstate travel. However, it is well established that there is no constitutional right to drive a motor vehicle. Driving is a privilege, not a right, and courts throughout Ohio and in the federal courts also have maintained that. And having accepted the privilege of driving, the defendant has also subjected himself to Ohio's traffic laws. The right to interstate and intrastate travel does not embody a right to a particular mode of transportation. The denial of a single mode of transportation does not rise to the level of a constitutional violation of a right to travel. The defendant has not cited to any federal law or state law that holds that requiring a car to be registered violates a person's constitutional right to travel. And in fact, a lot of these similar arguments that the defendant has made have already been raised. They've been raised in the states, in Ohio, they've been raised in federal courts, and the courts have routinely rejected these arguments and have held that these types of licensing laws do not violate a person's constitutional right to travel. Are there any questions on that before I move over to a court's subject matter and personal jurisdiction? No questions? Okay. The defendant also argues that the court did not have subject matter jurisdiction over him. But under the statute, a municipal court in Ohio has jurisdiction over misdemeanor offenses that occur within its territorial jurisdiction. And as for the Franklin County Municipal Court, that court has subject matter jurisdiction over misdemeanors that occur within Franklin County. And in this case, it's undisputed that not registering your vehicle is a misdemeanor, and it is also undisputed that the defendant's offense occurred within Franklin County, and therefore the Franklin County Municipal Court, by operation of statute, has subject matter jurisdiction over the offense. And personal jurisdiction, same argument by statute. Personal jurisdiction is established by service of summons that reasonably calculated to ensure the person's appearance. And I think it's undisputed here that the defendant was served with a summons through the Ohio Uniform Traffic Ticket, and he did appear in court, and therefore the court has subject matter or personal jurisdiction over him.